Different kinds of obligations. The obligation is divided into 5 classifications, namely, number 1, obligation according to demandability, either A. Pure, B. Conditional, C. With a term or period. Number 2, according to plurality of an object, either alternative or facultative. Number 3, according to plurality of subject, either single, joint, or solidary. Number 4, according to performance, either divisible or indivisible. Number 5, according to sanction for breach, A. No penal clause, B. With penal clause. Article 1179. Every obligation is one which is not subject to any condition and no specific date is mentioned for its fulfillment and is therefore immediately demandable. In this article, it talks about pure obligation. This is the obligation that is demandable at once because the performance have no condition and no term period of its specific fulfillment. Therefore, it is immediate demandable. An obligation is demandable and no term period if its specific obligation is subject to resolutory condition without prejudice to effect of the happening of the event. Article 1180. When the debtor binds himself to pay when his means permit him to do so, they shall deem to be one with a period subject to the provisions of Article 1197. It tackles about the obligation with a period, like future, uncertain. If the debtor will pay when his means permits him to do so, it is with a period. The obligation is not conditional, but with a period because it is part of the said law, but actually, the payment does not depend upon the will of the debtor. It is only the time when the obligation should be fulfilled. Article 1181. In conditional obligations, the acquisition of rights as well as the extinguishment or loss of those already acquired shall depend upon the happening of the event which constitutes the condition. This article is either suspensive or resolutory condition. When it is suspensive condition, it is the acquisition of arts, and the resolutory condition, it is the extinguishment or loss of those already acquired. Article 1182. When the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. If it depends upon chance or upon the will of the third person, the obligation shall take effect in conformity with the provisions of this code. In this article, we will understand protestative, casual, and mixed obligation. Protestative condition is a condition which once depends upon the will of one of the contracting parties. Casual condition depends upon chance or other factors and not upon the will of the contracting partners. Mixed condition is a will of the other contracting parties and other circumstances including the will of the third person. Article 1182. Impossible conditions, those contrary to good customs or public policy, and those prohibited by law, shall annul the obligation which depends upon them. If the obligation is indivisible, the part thereof which is not affected by the impossible or unlawful condition shall be valid. The condition not to do an impossible thing shall be considered as not having been agreed upon. Obviously, this provision takes about impossible and illegal conditions. The second kinds of impossible condition is either physical impossible conditions, This is the violation of the thing that cannot exist or cannot be done. Second is legally impossible conditions when they are contrary to law, morals, good, customs, public policy, or order. Article 1184. The condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires or if it has become indebatable that the event will not take place. This article refers to positive condition where the happening of the event at a determinate time extinguishes the obligations. Article 1185. The condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed, or if it has become evident that the event cannot occur. If not time have been fixed, the condition shall be deemed fulfilled at such time on may have probably been contemplated, bearing in mind the nature of the obligation. This article refers to negative conditions where it provides three situations. It's either when negative shall become effective and binding, or from the moment it has become an evident, or if it is no time is fixed, the circumstances shall be considered to determine the intentions of the parties. Article 1186. The condition shall be deemed fulfilled when the obligor voluntarily presumed its fulfillment. These conditions is also known as constructive fulfillment or presumed fulfillment. If voluntarily presents its fulfillment, the condition shall be deemed fulfilled. Article 1187. The effects of a conditional obligation to give aim the condition has been fulfilled shall retroact to the day of the contributions of the obligation. Nevertheless, when the obligation imposes reciprocal prestations upon the parties, the fruits and interests during the pendency of the condition shall be deemed to have been mutually compensated. If the obligation is unilateral, the debtor shall appropriate the fruits and interests received unless from the nature and circumstances of the obligation it should be inferred that the intention of the person constituting the same was different. This article means that there is no retroactive effect as to the fruits and interests, which means this article is applicable only to suspensive condition where there was fulfillment. The effects of conditional obligation to give shall retroact to the date of the constitution of the obligation if the suspensive condition had been fulfilled. Article 1188. The creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right. The debtor may recover what during the same time he has paid by mistake in case of a suspensive condition. In this article, it refers to the right of the debtor to recover what was paid by mistake. This is actually consistent with the principles of leisure indemnity, where one should be unjustly enrich himself as the expense. Article 1189. When the conditions have been imposed with the intentions and suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition. This article refers to the discussions about the loss, deterioration, and improvement during the pendency of a condition. This article applied only if the suspensive condition is fulfilled. The object is specific nor not generic. Article 1180. When the condition have for their purpose the extinguishment of an obligation to give, the parties, upon the fulfillment of said condition, shall return to each other what they have received. In case of loss, deterioration, or improvement of the thing, the provision which the respect to the debtor are laid down in the preceding article shall be applied to the party who is bound to return. This refers to the effect of fulfillment of resolutory condition. The effect of fulfillment of resolutory conditions may be if the obligation is extinguished, the parties should return or restore to each other what they have received, including the fruits and interest, and Rule 1189 will apply to whoever has got a duty to return in case of easy deterioration and improvement of the thing, and if the obligation is to do or not to do, courts are given the power to determine the retroactivity of the fulfillment of the conditions. Article 1189. The power to rescind obligation is implied in reciprocal ones in case one of the obligors should not comply with what is incumbent upon him. This provision talks about the right to rescind of the right to cancel the contract in case in the non-fulfillment in the part of their parties. The right to rescind only exists in reciprocal obligation. It can be demanded only if the parties is ready, willing, and able to comply with his own obligations and the other is not. Article 1192. In case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the sound shall be deemed extinguished and each shall bear his own damages. These provisions contemplate those situations. The first infractor shall be equitably tempered by the courts. Number 2, the contract shall be deemed and extinguished. Article 1193. Obligation for whose fulfillment a day certain has been fixed shall be demandable only when that day comes. Obligations with a resolutory period take effect at once, but terminate upon coronal of the day certain. A day certain is understood to be that which must necessarily comes, although it may not be known when. This article talks about the obligations with a period. Period is a length of time which determine the effectivity or extinguishment of an obligation. This article is either future or certain. This provision also defines a day certain, which means a day does not necessarily comes, although it may not be known when from a day certain. There are kinds of period according to source, according to effect, according to definiture. Article 1194. In case of loss, deterioration, or improvement of the thing before the arrival of the day certain, the rules in Article 1189 shall be observed. These provisions talks about the effect of loss, deterioration, and improvement before the said period. It is understood that the thing is lost when it is perishes or goes out of commands, as disappears in such a way that its existence is unknown or it cannot be recovered. Article 1195. Anything paid or delivered before the arrival of the period, the obligor being unaware of the period or believing that the obligation has become due and demandable, may the recovered with the fruits and interest. The provisions discusses all about the payment or delivery before the arrival of the period, which is effect of the payment before the said period has been made. Accordingly, the prepayment is made without the debtor being aware that the period is not arrived. Article 1196. Whenever in an obligation a period is designated, it is presumed to have been established for the benefit of both the creditor and the debtor, unless, from the tenor of the same or other circumstances, it should appear that the period has been established in favor of one of the other. In this article, benefits of period in an obligation has been discussed. The presumption is that the period of benefits of both the creditor and debtor. The effect of this presumption is the creditor are not allowed to demand for payment before the said period has been made, and the debtor should not allowed to demand to accept the payment before the agreed period.